Good afternoon.
Good afternoon.
In 1974, I finished 6 years of undergraduate and graduate study of English literature, particularly 17th century metaphysical poets, with a minor in philosophy. As a result, of course, I was totally unemployed. After a month of pounding the streets in Houston looking for a job, I saw an ad in the Houston Post that said, "Rub elbows with Houston's top attorneys. Call this number." It was the Harris County District Clerk's office, and I was hired as a deputy district clerk and assigned to the criminal district courts at that time, which were extremely busy. Houston had lots of crime back in the 70s, assaults, rapes, kidnappings, murders, a lot of capital murders because crooks had a habit of robbing a liquor store, and while going out the door with the money in their hand, they'd stop and shoot the clerk. So, of course, as you know, Harris County was the capital murder capital of the United States for a long time. So I sat right there next to the judge, hearing all those cases, hearing all the lawyers, Percy Foreman, Racehorse Haynes, Dick DeGuerin, Rusty Harden, and a bunch of others you never heard of that were just as good as they were. And that kind of got me interested in the law, because I'd watched Perry Mason forever. So I started law school in 1975. It took me 4 years, because I worked at the courthouse from 8 to 5, and then drove out to the University of Houston campus and was in class after getting my Coke out of the machine and eating my cheese sandwich I brought from home from 6 until 7:30, 8, or 9 o'clock. And every night as I sat there, I said, someday somebody's going to pay for this. And I'm happy to say now the state retirement system is paying for it. So I got out of law school. I was in private practice for a little less than 3 years, doing criminal work almost entirely, court appointments. I don't want to hear anybody whining about court appointments. I know all about court appointments. Thank you very much. But you can't go to trial as a defense attorney very often, as you will know probably. And I wanted to do that because I remember what Clarence Darrow said. How many of you know who Clarence Darrow was? The rest of you look him up. He was the premier lawyer of the early 20th century, the Scopes Monkey trial, Leopold Loeb, all that. And he said, the only real lawyers are trial lawyers, and trial lawyers try cases to juries. Well, that's what I wanted to do, so I got an opportunity to be hired as a felony prosecutor in Fort Bend County. And Fort Bend is just southwest of Houston, you know, Sugar Land, Rosenberg, Richmond, Missouri City. At that time, in 1982, when I was hired in Fort Bend, it was mostly rural, mostly farmland out there. Now you can walk across Fort Bend County on the tops of the rooftops, all the way across if you've been through that area. It's just astounding. We had a lot of crime at that time because the crooks at Houston had a habit of bringing their victims out to Fort Bend, murdering them, and leaving the bodies in the cornfield. So we had a lot of cases that ultimately became big-time things in Houston. Front page of the Houston Post, Houston Chronicle. We tried a lot of cases. It was great fun. We had a good time doing that. In 1991, I came here to join Bud Kirkendall in the district attorney's office. The DA's office at that time only handled felonies. The county attorneys did all the misdemeanors. The office consisted of Bud Kirkendall, Dwight Peschel, and me, and 2 secretaries. And we handled 4 counties, Guadalupe, Gonzales, Lavaca, and Colorado. And we handled them very well. Bud, despite what some people think, was an excellent trial lawyer. Nobody was better than Bud about rearing up on the final argument in righteous indignation and demanding that the jury exercise the conscience of the community and the wrath of God on this guy over here. Bud was very good at that. I got to be a judge before Bud did, so I never practiced in front of him. But I've heard from some of the other lawyers he was a little touchy on the bench. One time I understand he was having a real hard time with a lawyer who was arguing with him, irritating him, challenging all of his rulings. And finally Bud said, "Counselor, are you trying to show contempt for this court?" And the lawyer said, "No, Judge, I'm trying to conceal it." So I stayed with Bud for 12 years. In 20 years as an assistant DA, I personally participated in over 350 felony jury trials, most of them first chair. I averaged 15, 16 felony jury trials a year for 20 years every year. And if you don't believe me, ask Allison. In 2002, I was elected judge of this court. That's the proper way to approach the bench. And in the 19 years since, I've presided over 150 misdemeanor jury trials. So I've had a lot of trial experience. I have seen some of the best judges and lawyers in the state of Texas. I have seen some of the worst judges and lawyers in the state of Texas. And I watched them all from sitting right there in the courtroom. You don't have much of that opportunity. For whatever reason, there haven't been a lot of cases tried. The last couple of years is obviously one, but haven't been a lot of cases tried. There aren't a lot of big-time lawyers that I would advise you to go watch. We used to have a few lawyers from San Antonio come over, Roy and Bobby Barrera, Mark Stevens, if you get a chance to come watch their trials. Gary Trichter from Houston has come down to try a couple of DWIs here. If you get a chance, go watch some of those lawyers if you can, but there aren't many of them around anymore. So I thought perhaps I could give you a few thoughts on how it might be advisable for you to approach a criminal case. Well, the first question is, are you a real lawyer? What does it take to be a trial lawyer? Oratory, flashy speeches, having the jury waiting to hear the next golden drop falling from your lips? No. Oratory is dead in this day and time. Today it's Facebook and Twitter. No such thing as oratory. That doesn't get you anywhere. Flashy, big-time, front page, type A personalities, Percy Foreman? No. We're all conservatively dressed, very reasonably and properly raised, very nice people. We certainly wouldn't want to offend anybody, so that's not it. So that doesn't mean anything to be a trial lawyer. If you're a state's attorney, a good trial lawyer for the state is the lawyer who can get the facts into evidence before the jury without regard to the defense objections and without regard to the judge who doesn't know the law from a hole in the ground. That's what the prosecutor needs to do. Whether you do it loudly or quietly, you got to get the facts from the jury. Juries defend on facts, not oratory. So you've got to know the rules. The best way to do that, I think, of course, the prosecutors all have this book. All the defense attorneys should get one too. It's the best thing there is. It's got the law, the rules of evidence, penal code, criminal procedure, plus annotations, case citations that you can reach over and grab even in the middle of trial and get a citation. So get that. So you need to have rules of evidence. If you got a document that you want to get into evidence, how are you going to do it? What if somebody objects about the best evidence rule, whatever that is? I've never quite figured out what that is, but there is such a thing. If you got the document, is it self-proving, or are you going to need somebody to prove it up? What if you don't have anybody there to prove it up? Then what? You're always going to have some out-of-court statements, and you got to taking care of hearsay objections. You need to know what that is. Spontaneous utterance, present sense impression, whatever. It's in here. And be able to tell the judge, it's a present sense impression. That's the rule right here. I got it right here. You need to get that in over objections from the defense. Scientific evidence. Bud and I tried about the first case in the state of Texas that relied almost exclusively on DNA evidence. I didn't understand any of it. I don't understand how the lights work. I've never known that. I didn't understand how a scientist could reach into a cell and pull out a piece of chromosome and mess with it and match it up to some other cell's chromosomes. I didn't, but it can be done, and luckily Bud understood it. So he was able to try that to tell the jury how to do it. We bring in an expert, some professor from somewhere, not a law enforcement officer, no connection to the case. It was an esteemed professor who explained the process to the jury, and then we called in the DPS chemist who did the work, and the jury's never had a problem with that. They understood it, and we had some number of convictions with DNA evidence. You got to know how to do that stuff. Now, you've probably got to know how to get into evidence the contents of the defendant's cell phone. You got to know how to deal with the pings off the towers and all that. I don't understand any of that stuff, but you better understand it, because that's the stuff that's coming now, all that electronic stuff. You need to know how to do that stuff. So that's what you have to do as a prosecutor. If you're a defense attorney, you got to keep it all out. Yes, you just object to everything, is what a lawyer told me one day. Easy to be a defense attorney, just object to everything. But object properly. Irrelevant is not a good objection. Practically anything to do with the defendant is relevant. It may not be admissible, but it's relevant. So be able, using the same thing, to object properly and show the judge the rule that the state can't get away with that sort of thing. And do it in such a way that the jury can understand it. If you just jump up and say, objection, hearsay, and the judge says, sustained, and you all move on, somebody in the jury is saying, wait a minute, that sounded pretty good. I wanted to hear that. Why didn't that lawyer want me to hear that? So instead of doing that, why don't you say, Judge, this is calling for something somebody said outside the courtroom a long time ago, and that person's not here for me to ask any questions to see if he's telling the truth or not. This is just what this witness thinks he heard somebody else say, and that's hearsay, and I object to it. And the jury says, well, yeah, you can't believe anything somebody else heard somebody else say, so the jury understands that. So see if you can get away, if you can, without the judge saying, oh, with explaining your objection in a way the jury understands that sort of thing. Use a motion to suppress. Suppress whatever needs to be suppressed, field sobriety test, make sure it's reasonable. One lawyer was having a hearing on a motion to suppress and was just meandering all over the place and bringing up things that seemed totally irrelevant to the whole case. And the judge finally said, Counselor, just what do you want me to suppress? And the lawyer said, anything that is harmful to my client. Don't go too far with that and go off too far into left field. One lawyer was expressing a concern that the judge should rule in a way that was totally contrary to law and evidence, but he was just insistent on it and making a big deal out of it. And finally, the judge said, Counselor, what kind of fool do you think I am? And the lawyer said, well, I don't know, Judge, how many kinds are there? Use pretrial motions, file a motion to quash indictment. Something wrong with it. File a motion for expert witnesses, state's witnesses. Maybe the state will forget to put one of those witnesses on the list, and at trial, if you object, the judge might not let that expert testify. So go ahead and do those pretrial motions and do it, and get a ruling on it. And if you put them in the file and leave them there, you got nothing on appeal. Get a ruling from the judge, as much as she or he may hate to mess with it. Get a ruling on it. There was a lawyer in Houston who was well known as an appellate lawyer, and he would file a big raft of motions and hoping that somewhere in there the judge would make an erroneous ruling. He'd have something on to appeal. And this really ours is by Will Gray. So Will Gray walks into court one day and with a big stack of motions and puts them on the clerk's desk to be filed. The judge is on the bench. He looks over at him and says, Mr. Gray, all those motions are overruled. Later, someone went up to the lawyer and said, Will, any of those motions any good? And the lawyer said, no, most of them weren't, but he really should have read number 5. So put something in those motions to get rulings on. That's the only way you're going to get something on the field is having some mistake from the judge. All right, so you're a real lawyer now. You're ready to try a case. How are you going to get one to trial? State's attorneys have an easy way to do this. They'll bet there are 10 or 15 guys out there in the jail that have multiple prior felony convictions that would qualify for habitual criminal status. So get the mics to go get the pin packets, get their fingerprint charts, or however you do identification nowadays, maybe electronic means, I don't know, but there's some way to identify them. Get those pin packets, indict them as habitual criminal, and then don't plead them out for 5 or 6 years to do and drop the enhancements. Offer them 35. Offer them 40. And pretty soon you'll have a case to try. And they're easy cases to try because the reason they're habitual criminals is because they're stupid. They do stupid crimes and they leave a trail behind them a mile wide. So the cases are easy to deal with. And then when you convict them at punishment, when you go over here and you lay all those prior pin packets with those prior convictions in front of the jury, the weakest sob sister on the jury is going to say, what? He's done this before? Oh my goodness, and they'll win. Mr. Fisher, who's not here today, just got a nice write-up in the paper the other day, because after you do that and if the jury whams them, gives them a big line sentence, you call the newspaper. Call Mr. Moultrie or whoever you said, Cindy at the AWD, and give them the story. They got to fill up their pages every day. And rather than have them come down here and try to find somebody to talk to, call them up and say, I got a story for you. And they can sit right at their desk, type up whatever it is you tell them, and they'll print it on the headlines the next day, and you get your name in the paper. And of course, you get your name and also point out, as Mr. Fisher wisely did, that also participating was your elected county attorney, Mr. Dave Wilburn. And if you don't think that's important, ask Dave. He's up for re-election, not you. So get that name in the paper. It's easy to do, and the reporters are happy to print that stuff. If you're a defense attorney, you probably have one or two knucklehead clients who don't believe anything you tell them, who don't listen to your advice, who think they're smarter than you are, who get their advice from the guys out at the jail. And it never seems to occur to them to ask the guys in the cell, if you guys are so smart, how come you're in the same cell with me? But, of course, as we know, if they were smart, we'd all be out of a job. So that's what you do. So don't lay awake at night worried about what to do about those clients. Don't argue with them about it. Set a trial. Give them the benefit of the American justice system. Give them the opportunity to prove their innocence, as they've been telling you for the last 6 months. And go ahead and do that thing and try it and do the best you can, and that's it. And you can get rid of the case that way. They're still going to file a grievance against you, of course, but it's a lot easier to defend against it if you have a full jury trial that you can point to rather than copying a quick plea. So that's one way is to get for defense attorneys to get to trial is just try it, set it for trial, let the defendant have his way. The judges don't love me to say this, but never waive a jury and try a case to the judge. Unless you are absolutely sure that because of personal, family, political reasons, the judge is going to rule in favor of your client, which happens. I had a judge one time who would grant motions to suppress because he didn't like the way the officer treated the defendant, and he would say from the bench, I wouldn't want an officer treating my wife or my son that way, so I'm going to grant this motion to suppress. Had one judge one time that acquitted several city officials charged with misapplying city funds because he was up for re-election pretty soon and he needed all their votes. And if you don't think that happens, you're in the wrong profession. You may be in the wrong universe if you don't think that happens. So unless you know that the judge has got some reason to go for your client, don't do that. Because it's like Darrell Royal said, when you throw a forward pass, 3 things can happen and 2 of them are bad. The opposite is true for defense attorneys and defendants. If you try a case to a jury, 3 things can happen and 2 of them are good. One's an acquittal and 2 is a hung jury, which is almost as good. No prosecutor wants to try the same case twice. No case gets better for the state the second time around. Second time around, witnesses are going to make a mistake, they're going to change, they're going to say it happened at 10:30, but the last trial they said it happened at 10:40. This time they say the defendant was wearing green socks. Last time they said he was wearing red socks, and you, the defense attorney, is standing there with the transcript of the first trial, so you can point out all this stuff, and the jury just hates it, especially with police officers. They will not cut police officers any slack at all on that sort of thing. If they find an officer changing his testimony, even to the most minor things, they will go against him. So, no prosecutor wants to try it the second time. However, and again, if you try a case to a judge, only 2 things can happen, and one of them is very, very bad. And whatever happens, you're stuck with it. Because you can appeal all you want, but the Court of Appeals is going to say, well, the learned trial judge may have fallen into error in this case. Well, we can't say that it substantially affected the verdict, so we're going to affirm the conviction and the 99-year sentence that goes with it, and explain that to your client. So, don't do that. You cannot get anywhere on an appeal, a judge, trial, judge, verdict. With a jury, maybe you'll get jury misconduct. Maybe the judge wrongfully granted the state's challenge. Maybe he wrongfully denied the defense challenge. Maybe the judge gave erroneous instructions to the jury in the charge. Something might happen, but you ain't going to get it with a judge trial. So keep that in mind and don't tell any of the judges I told you. You're ready to go to trial now. Before you go to trial, read your indictment, and I mean read it. Get a copy of the penal code and hold it side by side and see if the indictment the state's presented, and when I say indictment, I also mean information, if it comports with the statute. In 1981, I was co-counsel with Dick DeGuerin. We had co-defendants who were charged with theft in a big-time case. One rich, powerful guy in town was the victim. Front page Houston Post stories and all that kind of stuff. It's another long story. And one Monday afternoon, Dick called me and said, "Have you seen the cases that the Court of Criminal Appeals handed down this morning?" I said, "Well, no, haven't quite gotten around to seeing the cases that were handed down this morning, but Dick had, and that's why he's rich and famous and I'm not." And that day, the Court of Criminal Appeals had handed down Thomas versus State, which invalidated all of the theft indictments in Harris County because they failed to include one of the elements from the statute. I think it was the intent to deprive the owner of the privilege of the property, something like that. So Dick said, "Meet me in court at 9 o'clock next morning." So we go to court at 9 o'clock, go in front of the judge. Dick presents the judge with a copy of Thomas versus State and demands the indictments be dismissed. The judge looks at me and I say, "Me too." And the judge dismissed the indictments. And by this time, the state had figured out there was something real fishy about this case. And so they never re-indicted on that. So that's possible. If you could get that indictment thrown out, possibly it won't get re-indicted. Or at least it's making the state scramble a bit, making the prosecutor think if he really wants to put any more energy into this stupid case, which sometimes you don't. I mean, some cases are not worth the trouble. So make it as hard as you can. If there's words or phrases in the charge and the indictment that have definitions of the penal code, look them up. Don't assume anything. I was trying to burglar a building one time where a guy was accused of driving while intoxicated on public road or highway. And what happened was someone was driving down I-10 and they called the sheriff's department and they said, "There's a guy out here driving 100 miles an hour, running people off the road, and he's causing wrecks and all that kind of stuff." So the sheriff sent somebody out and they couldn't find anybody on the highway, but the officer decided to take a chance to go to Judd's truck stop up on I-10 at 123. And sure enough, there was the described car sitting at the gas pump. And as he's sitting there watching, out from the store comes the defendant, stumbling along badly, gets in his car, tries to drive off. The officer stops him within 10 or 15 feet of the gas pumps. The guy's drunk as a skunk, and so he's arrested. So we go to trial on that thing, and as we're doing the trial, it recurs to me, now look, check my indictment again, and it says the defendant was operating his vehicle on a public road and highway. Of course, the officer didn't see him on the public road. He never got out of the judge's parking lot. The citizen, of course, was an anonymous caller. We don't know who that person was. We didn't have any idea. So there was nobody to prove that. So I decided, well, this is going to be one I choke up to experience, and I'll take the rest of the week off. So I just waited for the defendant to make his motion for instructed verdict, and we could all go home. So when I arrested, the defense attorney did not make a motion for instructed verdict. He put his client on the stand, who testified, "Well, I was just driving in from Houston on I-10, and I swore I stopped at that truck stop." So we got a conviction out of that, proving again one of the oldest and truest maxims of the law. Sometimes it's better to be lucky than good. All right. Now, the original indictment, you need a trial strategy of some sort. The state always has a trial strategy. He did it, and we're going to prove it. The defense often doesn't have a strong strategy. Sometimes you're just counterpunching against whatever the state may throw up. But it'd be helpful to think if you could come up with some. Maybe have self-defense, mistaken ID, which leads to the time-honored defense of SODDI. Some other dude did it. And then, of course, if nothing else, you could just argue sufficient, insufficient evidence against it. You're going to have some idea of what it is you're going to be looking for as you hear the testimony, how you're going to cross-examine people, what you're going to try to get across to the jury. Racehorse Haynes said that there's always multiple defenses to a case. Say, for example, you're charged with letting your dog run loose and it bites a child. Well, your first defense is, "It wasn't my dog." Well, if that doesn't work, you fall back on, "My dog doesn't bite." If all else fails, you can come down to, "I don't even have a dog." And then at least some defense that you can put up in some way. DeGuerin again. Dick DeGuerin's the best trial lawyer I've ever seen, and I've seen lots and lots of them since 1974. And he just got his client, Mr. Durst, got convicted out in California, finally, of killing his girlfriend or wife because she was going to tell about how he killed his other girlfriend or wife, whatever that story was. And he just got convicted. He was formerly a millionaire. Maybe not now, because DeGuerin was a protege of Percy Foreman. And Foreman, maybe before most of y'all's time, was famous for taking everything he could get from a defendant to represent him. He'd take his house, his car, his boats, airplanes, Rolex watches, whatever he wanted. And so one time Foreman walked into court and the judge saw him and said, "Well, Mr. Foreman, your client must be a rich man." And Foreman said, "He was, Your Honor. He was." So DeGuerin probably sucked him dry, Durst anyway. But you remember several years ago, Durst was tried for murder here in Texas. And the story was he and a neighbor got into some kind of dispute. The neighbor ends up shot to death. Durst cut his head off, took it down to the coast and threw it into the Gulf, disposed of the body, and then fled to Illinois, where he tried to escape detection by posing as a woman, wearing a dress and a wig. Well, he was finally caught, brought back to Texas, tried, and acquitted. Jury found him not guilty. How could that be? He cut the guy's head off. Well, because Dick's trial strategy from the beginning was looking at the indictment, which said the defendant was charged with intentionally and unlawfully causing the death of the neighbor. He wasn't charged with cutting his head off. And so Dick's argument was everything that happens that's important was up to the cause of death. What happened after the death doesn't count. And the jury said, okay. And they did that. And they found him not guilty. And that's just a trial strategy that Dick had, which worked. And he started in voir dire, opening statement, final argument, same thing to impress upon the jury. And they believed it. One of my favorite courtroom cartoons is a picture of a jury foreman standing up and he's facing the judge. And he says, "Well, it was a lot to ask a jury to believe, but we fell for it." And that happens. All right. Then you finally get down to voir dire. And that's the way it's pronounced, not like some hoity-toity lawyers that say, "voir dire." No, this is Texas, by God. It's voir dire. And you pick a jury. Of course, you don't pick a jury. You all know that. You get rid of the ones you don't want. That's the ones you got to get rid of. The goofballs and the nuts on the jury are the ones you don't want. Most people who show up for jury service are decent, common sense, law-abiding folks. And if you show them clear jury instructions, setting out what the crime is, and then give them the facts that either support that or do not support it, they will usually come to the right decision. Not always, for God's sake, I can testify to that, but usually they'll come to the right thing. So if the people who don't show up, you don't want anyway. If there's somebody who gets a jury summons and throws it in the trash, I don't want him down here on a jury anyway. We had a visiting judge some years ago who got all upset because people didn't show up on jury day. He sent the sheriff out, ordered him to go find those people and bring them in. Well, the sheriff found one little woman who came in and had 3 children and was working 2 jobs to support them. And she ended up in front of the judge with tears running down her face and said, "I just forgot." Well, what's the judge going to do? I don't believe he put her in jail. So those people you don't want. Don't ever encourage the judge or suggest that he go round up people. If you don't have enough people to pick a jury, let them all go. Take the rest of the week off and try it next time. Don't get those losers in who don't want to be there in the first place. Most lawyers are not very good at getting jurors to open up. Most people don't want to get up and talk in front of a bunch of strangers, especially about some private feelings they have about crime or people or something like that. It's not very good. I wasn't very good about it at all. So, you don't have much time. I only gave people 30 minutes for voir dire, and there's hardly ever any problem with that from my point of view. Well, I got very few complaints about that. There were a couple of lawyers who just begged and pleaded for 45 minutes. And I let them do it because I knew them to be good, experienced lawyers. Maybe I'd try a case against them when I was in the DA's office. And I thought they could use the time profitably and not waste it. None of them ever took 45 minutes. At 35, 40 minutes, they quit. They just had anything else to say. So, but you don't have much time. So don't waste the time that you have. Don't be trying to pry a bunch of opinions out of the jurors who don't want to give them to you. Don't ask, well, Ms. Smith, are you in favor of the DWI laws? And she doesn't know what the DWI laws are in the first place. And she's not going to say whether she is or not in front of these people. You're the one that's supposed to know the law. So it doesn't matter what her belief about the DWI laws are. If you show her that the defendant's driving 100 miles an hour, running cars off the road, had an accident that hurt a child, and he blew a 2-1, her attitude is probably going to be she's going to convict. It doesn't matter what she thinks about the law. Don't worry about that too much. I've had lawyers ask people what their favorite TV program is, what their favorite movie is. And one lawyer asked them what their favorite color is. Well, it's your case. It's your personality. You have to try the case you want to do. That's fine. Okay. I don't think, however, that's getting you very far along in making your challenges or your strikes, which is the point, the whole thing. So I think you should get down to asking them things that are more important. Tell them what they need to know. Don't ask them. Tell them. The elements of burglary are this. And you know how I know that? Because at the end of this case, the judge is going to give you a set of instructions, just like this. And that judge is going to tell you that burglary consists of this, 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 and this. And that's what the judge is going to say, not me, the sleazy fly-by-night lawyer. The judge is going to tell you that. And so that's what you need to know. And since I'm going to show you all the facts that prove that, you'll find the defendant guilty. Tell the jury what they need to know in order to convict or to acquit. If you have a self-defense case or whatever, alibi, whatever it is, tell the jury the judge is going to give you instructions telling you who has to prove what when it comes to self-defense. And what happens if the state doesn't do it? Then you find not guilty. The judge is going to tell you that in here. Use that. Always have a copy of the charge sheet. All right. Don't use those number cards.
Oh, I love them.
I think that's horrible. Mr. Smith is not going to be upset if you get confused and call him Mr. Brown. Everybody makes mistakes like that. But he might get upset if you continue to call him number 4, especially when you turn to your colleague and say, no, make a note, number 4 says he's prejudiced. I don't think he's going to like that. Get rid of those number cards. This is not hard. You know, in misdemeanor cases, you only got about the first 17, 18 people to worry about. It's 1 to 6, 7 to 12. It should be easy for you to make some kind of schedule or chart or grid or something so you can quickly say, 4, 1, 2, 3, 4, Mr. Smith. That can't be too hard to do, so get away with the cards. There was a lawyer back in Houston in the 70s, and the assistant DA who was famous for taking one look at the jury list and memorizing everybody's name. So from the minute he got up, he'd be immediately saying, Mr. Jones, what do you think about that? Oh, Miss Green over here, Miss Smith on the back row, what do you think about that? It was amazing to watch him do it. And unfortunately, that was the only trial skill he had. Fred Reynolds was good at watching. When the trial started, he had no idea how to try a case. And so he got so many not guilties that finally the DA moved him to the hot check division, which was the graveyard of the DA's office. And that's where he remained for the rest of his tenure. So, but it should be easy to make some kind of adjustment so you can get these names down, roughly speaking, in order to do that. One thing lawyers have not done, I've seen over and over again, every jury has some people who under occupation write self-employed or retired. And over again, no one ever asked them what they retired from. I would like to know that if I was picking a jury and was going to make challenges. I'd like to know if a person retired after spending 30 years as a psychology professor at UT in Austin, or if they spent 30 years as a prison guard. I think that would make a big difference in how I make my strides. Ask them those questions and find out. I've had a lawyer, several lawyers, said, Miss Smith says here you're a housewife, so you've never worked?
Oh.
He just lost every woman on the jury. Now there's a way to do that. He said, Miss Smith, have you ever worked outside the home? And that's how you find out that for many years she was a psychology professor at UT. Do it, but don't insult people. Watch jargon. The state has the burden. They have to carry the burden. The burden never shared. The jury say, what burden? This little thing, a couple of books, that's not, what a bunch of wimps. That's not much of a burden. shift, the prosecutor's going to take the burden and put it over here for some reason. The state has the responsibility of proving the defendant guilty beyond a reasonable doubt. Get away from that. Charge. What's the charge? Jury know what the charge is. They know that there's a set of written instructions that the judge is going to give, that he will read to you, that tell you what the law is. That's what, don't say charge. Okay, one thing that always irritates me. Ms. Smith, if you had to vote right now, how would you vote, guilty or not guilty?
Oh,
And Ms. Smith, like 99 out of 100 jurors, would say, well, I don't know, I hadn't heard any evidence, I don't know how I would vote. And then you say, wrong, you ignorant hillbilly. Haven't you been listening? The defendant is presumed to be innocent. You have to vote not guilty. Ms. Smith said, well, excuse me. You're supposed to know the law, not me. Why are you asking me? And besides, it doesn't make any sense to me that I'm supposed to vote before I've heard any evidence. That doesn't, don't do that. That just gets, and everybody else in the jury is saying, well, I'm not going to say anything now, boy. I'm not going to let that lawyer make a fool out of me. So you just lost the whole jury doing that kind of stuff. Don't do that. Ignore the troublemakers. There's always some goofball out there who wants to say, 2 years ago, my brother-in-law was arrested, and it was just totally bogus, and the police had no evidence, and the prosecutors were crooked, and the judge was on the take. You go, and you got to shut him up if you're a prosecutor. Now, I'm talking about prosecutors. Shut him up.
Shut him up.
Shut him up. And then I've seen the same prosecutor later. He raises his hand. They go back to, oh yes, Mr. Smith, you have something else to say, and he goes into it again. And the judge was paid off and going all this stuff. Ignore those guys. Don't call them. If he raises his hand, let the blood drain out of his arm rather than call him. They're going to hurt his feelings, so what? He's not going to be on the jury anyway. If he makes it past the challenge, you're going to strike him. So he's never going to be on the jury, so who cares what he thinks? So don't let those guys run away. And again, that's one reason when you start asking jurors so much about what they think, you get all kinds of strange stuff back that you may not want. The defense likes it. They're chortling over. Look at these guys just laughing over here about it. Right. So but don't get rid of those guys. Give some thought of what kind of jurors you want. You can't pick them exactly, but you can get some idea. If you're trying a child molesting case, the defense probably doesn't want some grandmother who has 5 grandchildren under the age of 10. That's not your kind of juror. The state may want a guy who's 60 years old, never been married, never had any children. He might be more acceptable in that case. It makes a difference. You can't pick them, but you can kind of give some parameters to what kind of jurors you think would identify with your case and with your client, if you can. A lawyer back in Houston again was trying a murder case, and he used his challenges and strikes somehow to craft a jury that was the meanest looking bunch anybody ever seen. Just 12 guys, pipe fitters from Pasadena, oil field workers, long haul truckers, a guy with Marine Corps on one corner and Mama on the other. Mean looking bunch. Did not look like a group that would be sympathetic to the defendant in a murder case. And somebody said, well, Ray, why did you pick a jury like that? He said, well, because our defense is that some bitch needed killing and my client needed to kill it. And all of those men knew somebody exactly like that in their lives. And they said, yep, we agree, found him not guilty. So that particular jury needed that kind of juror. He picked the ones that would do things that would be conducive to his client. All right, now you're in trial. You've got a jury picked opening statement. The state should always make an opening statement. Always get up in front of the jury every time you can. Try to convince the jury that you are the one. And of course, the same goes for the defense. Be in front of the jury all you can. Show the jury that you are the reasonable, common sense person. So when there's an argument between the lawyers and the jury may be inclined to think, well, you know, that person's really, I like that one. I think I'll go with him. So always make an opening statement. Tell them that you know they don't know anything about the case, so you're going to give them kind of a roadmap and just what you anticipate the evidence may be in this case. And stick to that. Don't get off into argument, because if you do, you're just drawing an objection from the defense, and you don't want to have an objection. You don't want the jury to be distracted. You want them to have their attention on you, not the defense. So don't get off into argument. Just give them the facts. We're going to show you this, 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 and this, and that'll show you the defendant's guilty. Of course, some defense attorneys are going to object anyway. So if they do, say, well, in all innocence. Well, Judge, I'm just trying to give the jury an idea of what the evidence is going to be so they can follow it. I'm just trying to help the jury. Unlike this guy over here, the defense attorney, who's not trying to help. Anyway, that's supposed to be a laugh line.
No, we're not.
So, anyway, so that's what your opening statement is. With defense, you can make your opening statement after the state, or you can reserve it until after the state rest. If you don't have anything in particular to say, you might as well get up and do it after the state. Why give the state a free speech, let him get the jury thinking one way? You can at least get up and say, now, wait a minute, gentlemen, wait till you hear all the evidence. Don't make up your mind too soon. There may be some witnesses who change their story, maybe some witnesses who are prejudiced. So make sure you listen to everything. Just say something. And of course, you'll always get around to saying, and remember, my time is presumed innocent, and the state has to prove him guilty, which is argument, but the judge will let you do it because you probably don't have much else to say anyway, and every defense attorney does it. So go ahead and do that. But if you don't have anything particular, now if you've got something particular that you want to do, like for example, a secret witness that you haven't told the state about, and you're going to lay behind the log and wait till after the state rest and then spring this witness on the defendant, then you may not want to make an opening statement and give him a warning of that. Just wait until after the state rest to spring your opening statement and your witness. Now, if the state's attorney has a secret witness that he doesn't tell the defense about, that's prosecutorial misconduct. If the defense does it, it's trial strategy. Unfortunately, that's the way it is. So, that happened to me in a murder case. I was trying this murder case back in Fort Bend, and a 19, 20-year-old boy had his big problems with his dad. They had a very fractious relationship. So one day the dad comes home, he parks his truck, he gets out of the truck, and he looks up and there's his son that's some 50 feet away. The son levels his rifle across the hood of his truck and shoots the dad, and dad is what the police call DRT, dead right there. Well, looks like a pretty simple case to me. No possible chance of self-defense, easy case. So we tried the case because we don't offer him anything. Forget it. We didn't offer 5 years. We offered 50. Anyway, so we tried the case to the jury. And then after our arrest, the defense attorney calls a witness to the stand who says he was right there the whole time. And he saw that when Daddy stopped and got out of the truck, he saw his son over there. And then he reached into the truck and pulled out a rifle. And the son, who was just minding his own business, not bothering anybody over there, when he saw Daddy get the rifle, he knew Daddy was going to shoot him, so that's why he shot Daddy. So obviously it's self-defense. Well, nobody else had seen that, so I knew it was a lie. So after some rather rigorous cross-examination, the witness admitted that, in fact, he did not see Daddy get the gun out of the truck. And that's what I call a close encounter with the Mary Mason kind. And so the jury convicted in that case. The lawyer in that case was, at that time, the president of the National Association of Criminal Defense Lawyers. That same year, I tried a murder case against a lawyer from Brownsville, who was, at that time, the president of the Texas Association of Criminal Defense Lawyers. Unfortunately, there was no association of assistant district attorneys. If there had been, I've been voted into the Hall of Fame. We had great fun back in Fort Bend County, big time case. Good. All right. Now, you got to sum all this up. You got to make a final argument. This is the fun part. That was the best part. That's what kept me going for so many years, having a chance to get up before the jury and make a final argument. One lawyer I knew used to say that he would work on that first. The first thing he did when he was thinking he was going to trial was work out a final argument, and then tailor everything else in the case, his cross, his witnesses, down to whatever it was he was going to say in the final argument. Pretty good strategy. You don't have a lot of time on this either. The judge never gives you enough time. You think you don't have enough time. So don't waste time. Don't thank the jury for coming. We appreciate your coming and glad you're here. They got a card in the mail that said if they didn't show up, the judge was going to fine them and put them in jail. They're not doing you any favors by being here, so don't waste time with stuff like that. Start talking about whatever it is, the facts that you need to give them, and do that. Don't tell them the court reporter can read the testimony back if they have a question. Not only will we irritate the judge, we'll make a lifetime enemy of the court. Court reporters hate that. Now, another clue here is you get paid for messing with the other lawyers, and sometimes you have to mess with the judge. But there is never any future in messing with the court reporter, the clerk, or the bailiff. Those people can hurt you. Don't mess with them. So, and then the jury thinks that the court reporter's machine is like a typewriter. So invariably they'll send out a note saying, we'd like a transcript of the trial. And the judge says, no, you can't have it. And then they say, well, wait a minute, that lawyer told us we could do that. How come he said that? You know, don't set that up. Don't set that court. All right, so you got to make an argument. Work on that considerably. Don't get up and say, well, ladies and gentlemen, thank you all for coming, and we appreciate your patience for listening to these 3 days of terribly boring testimony, but we appreciate you coming here, and we think we've carried our burden, and so we hope that you convict this gentleman of something or other. Thank you very much. You couldn't sell a used car or something like that. And he ain't no gentleman. Put that word out. Never use that word again. He's a gentleman. He ain't no gentleman, of course. He's charged with child molesting, for God's sake. He's not a gentleman. So don't do that. Instead, put your notes down, look each juror in the eye, and say something like this. Every day in this courtroom, there's a constant struggle between good and evil. And I'm sorry to tell you that on some days, evil wins. This should not be one of those days. What this defendant did was evil. What he did was murder. And you should find him guilty of murder. Let the last words ringing in the jurors' ears as they go, guilty of murder. Let them hear that. Defense attorneys. Man, thank you, ladies and gentlemen. I'm glad you came. Thank you for your time. And we hope that you'll quickly find my client not guilty, and so we restore him to his family. And the jurors thinking, he didn't give a damn about the victim's family, did he, when he committed the crime? We don't care about his family. Instead, try something like that. There's a golden thread that runs through the fabric of English and American jurisprudence, and that golden thread is the presumption of innocence. Under our law, every defendant, no matter how low, no matter how unpopular, no matter how vile, is presumed to be innocent until and unless the state can prove him guilty beyond any reasonable doubt. The judge will tell you in his instructions that unless you find the defendant guilty beyond any reasonable doubt, it is your duty to acquit. The prosecutor says he wants you to follow the law. Well, so do I. The state has failed to prove Tom guilty. And therefore, under our law, it is your duty to return a verdict of not guilty. Okay. Now, that argument is usually strengthened considerably if, in fact, the state has failed to prove your guilt. But make the argument anyway. Hell, you got to say something anyway. It doesn't make it good. How many of you are familiar with Rumpole of the Bailey? A few. And I know why you are. Rumpole of the Bailey was the subject of a series of books written by an English barrister named John Mortimer, and later made into a fabulous British television series. The best courtroom scenes ever, starring Leo McKern, who was born to play Horace Rumpole. Horace Rumpole was what he called himself, an Old Bailey hack. Spent many years in the English courts, disheveled, cigar smoking, the little cigars like Clint Eastwood had, wine drinking, and Shakespeare quoting barrister who always defended and never prosecuted. And after all those years, Rumpole declared that the practice of criminal law had provided him with a lifetime of harmless fun. So, I hope in the future you will be prepared for trial. Believe in yourself. Have fun. And may all your verdicts be happy ones. Thank you.